Okay. Oh, that's loud. Can you hear me?
I think so.
If you can't, well. All right. So for all those people who are enjoying the discussions that you're having, networking is really probably the best part of these conferences, rather than what we say. So we're going to start saying, and you can sit down, get yourself over to your tables, and of course, for antitrust, network effects are very important. That's my first antitrust joke, just to give you a little, okay. So, welcome to, do we have the slide up for the next panel? You people from Concurrence. We do, okay. So, welcome back. As you can see from the slide, the topic for this panel is mega mergers and developing countries. Mega mergers as opposed to plain old mergers. I'm not going to define for you mega mergers, but just to sort of set the context a little bit, as I think anyone who observes the scene of merger and acquisition activity, it's growing in volume, and large-size mergers are growing both in numbers and in size. So a little sense of the data. 2017 total global deal value was $3.7 trillion, which, as someone once said, is a lot of zeros. Fourth busiest year on record. 46 deals over $10 billion, however we want to define mega mergers. In 2016, it was 45 deals, 35 over $50 billion. For the first half of 2018, $2.5 trillion announced in the first half, which puts it on pace greater than 2017. $1 trillion in cross-border deals. So as we try to keep our focus here on the impact on developing countries and economies, we want to consider how mega mergers in that sense as cross-border deals have a particular effect and impact. And in the first half, there were 36 deals over $10 billion each, valued at $950 billion. So I keep repeating the billions. So this is about 4 times the value of large transactions in 2017. So recent examples, you can probably think of them, and we may talk about some of them on the panel. Seeds and chemicals and fertilizers, Dow DuPont, Bayer Monsanto, ChemChina Syngenta. We have telecom and entertainment, Disney Fox. Beer, a little further back, the AB InBev SAB Miller, which was $101 billion, involving some countries really across the globe, including South Africa. Cement, important merger, Lafarge Holcim in 2015. Of course, we have the high-tech mergers, which were not necessarily mega mergers, although some were. We always have to mention Qualcomm, since Cleary's here. Qualcomm NXP Semiconductors, still in process maybe, or maybe not, $44 billion. Walmart, majority stake in Flipkart, India's leading e-commerce platform, at $16 billion, announced May 2018. So Walmart's still in the news for us. And maybe one that will come up, which is sort of a spectacular fail, which is Broadcom's effort to take over Qualcomm at roughly $130 billion. So mega mergers are clearly on the charts. And the focus on size in part, it reflects a number of things. So first of all, what we might think of as the major industrial countries and their competition authorities have trouble with these mergers. They're huge, understanding them, getting a hold of the data, the information, the documents is a challenge for them. What sort of challenge is it for developing countries which do not have the enforcement resources that are the equivalent? They may also present, given the cross-border aspect, different issues in different markets. So one of the tensions that we talk about, in terms of sort of global standards in antitrust, but that sort of the other side of that, which was part of the discussion in the first panel, is that different countries have both different institutions and different economies. So small and developing countries, their markets may look totally different than, let's say, a large market like Europe or the United States. So that presents a particular, maybe different problems in different countries. The flip side of this, and it's something I hope we'll discuss, is do these mega mergers present some opportunities for developing countries to, let's say, achieve certain goals that enforcers in developed countries might not have? We might look on this as opportunistic or something that could actually help developing countries. And we saw a little bit of that discussion in effect in the Walmart-Massmart merger, where South Africa was able to turn this acquisition into something that might help the South African economy. And an overall question of whether these mergers have any good impacts in developing countries, which after all is the focus of this conference. So with sort of that general background in mind, let me introduce our panelists. It's always good to say we have the most fantastic panel until the next panel, but we do have great speakers, I have to say. And one of the things that we try to do is, and it came out a little bit also in the first panel, sometimes where we stand may depend a little on where we sit. But the good part of that is that people have different perspectives on these issues. So we want to try to hear those perspectives. And again, that's one of the things to do in the conference. So I decided we're doing the panel in alphabetical order. I was going to do it in size order, but I wasn't sure, who the tallest person was. It wasn't going to be me. So I just decided to do it but it'll work out, I'm sure. So Bonakele, our first speaker here. Everyone is to my right. You can take that however you like. Tembi is a repeat offender here been at past conferences. And therefore gets asked back, but has been with the commission, the Competition Commission in South Africa for about the past 10 years. He's now the commissioner, has had other positions, worked on all of the commission's major cases in the past decade. And there have been quite a number of them, and has a particularly important position in some sense in competition authorities in Africa as well, chairperson of the African Competition Forum. Tembi, as previously, his experience is that he is a practicing lawyer, practiced both in South Africa and in New York for a period. And I say this because the path to become head of a competition authority, we're used to in the US being lawyers, but it's not always the case. Sometimes it's politicians, as we know from Europe. So it's interesting to think about who's heading commissions in various countries. Our next speaker from the private bar, Gönenç Gürkaynak, is the founding partner of ELIG Gürkaynak. which is probably, the largest law firm in Turkey, or at least they say they're the largest law firm, which is, you got to go with that. Gönenç has practiced law really in lots of other parts in the world, and has also represented a lot of clients before the Turkish Competition Authority, including in many merger cases. So he speaks broadly around the world on issues of competition policy, and has written extensively on it, and also a past performer here, not performer, but participant here. Lawson Hunter is new to, we always have some new people to the conference, formerly Canada's senior civil servant in charge of competition policy and enforcement, and primarily responsible for the drafting of the Federal Competition Act. He's been a partner at Stikeman Elliot various times, is now back there, and has, again, as others on the panel, been heavily involved as an advisor on various merger transactions. Nick Levy, next down the line, is a partner at Cleary Gottlieb, based in Brussels and London, and generally does a lot of representation in various areas of antitrust law, but also has been heavily involved in many important EU merger cases. Authored a 2-volume treatise entitled European Merger Control Law, a guide to the merger regulation. And since Concurrence is our co-venturer here, I should say that in 2015 won a Concurrence Antitrust Writing Award. So that's important to note. And finally, at the very right end of the panel is Ioannis Lianos, Chair of Global Competition Law and Public Policy at UCL Law, University College of London. But actually, Ioannis teaches in every law school in the world at once. So I asked him whether he teaches on Skype, because it seems to me that would be very efficient to do. So I'll just read it to you. He's the Gutenberg Research Chair at École Nationale d'Administration, visiting professor, National Research University Higher School of Economics in Moscow, also visitor at Humboldt University, Strasbourg, Chile, Hong Kong. Most importantly, he was an Emile Noel Fellow here at the law school, the Jean Monnet Center. And most important is has a master's degree, an LLM degree from this law school, which I think is the most important qualification, but is very widely published in competition law and economics matters, and is well known throughout the world. So with that in mind, we're going to turn first to have each of our panelists give an opening round of about 5 minutes with the main points that they want to make. And we're going to hopefully talk about 4 issues, although these may get intertwined. That's why I want to say them now, so we know that these things are coming up. So we have process and procedures. A lot of the points that I think we'll be discussing, we've started the discussion in the first panel or with Joe Stiglitz's opening talk. So process and procedures, legal standards, how much of merger law, and particularly in mega merger cases, are we talking law, or is this something else going on? And in a sense that maybe goes over a little to the industrial policy discussion that we were having in the first round. Remedies, which is a really important issue, particularly in the merger area, and that we'll need to discuss. And then the fourth one is also something we've raised, which is what people refer to as public interest issues outside of antitrust, as if antitrust is not in the public interest. I don't understand that dichotomy. So we'll talk about how what we think of as public interest issues come up in merger review. So I'm going to start out with Tembi. I'll turn it over to you.
Thank you. We now have 5 minutes. I thought it was 10. But so
This is already a negotiation. And, you know, obviously you do merger work, right? So let's make it 7.5. Go.
okay, so maybe starting with the good news is that merger regulation is probably the most advanced area in terms of global cooperation within the ICN. Countries bilaterally talk quite a lot. Almost all the most active jurisdictions, heads of mergers, know each other by name. They can call each other up. And so in that score, I think we've made a lot of progress as the international community. The one thing, though, that is troubling about merger regulation are the outcomes. So if you look at various commentators' commentary about the global economies, that it is increasingly concentrating. And yet we have all of these measures, and you hardly have what you call mega measures disallowed. In fact, I can't think of any, as I sit here, of a so-called mega measure which has not been approved. So message coming from competition authorities is that there is generally no problem, or at least there's no problem that cannot be remedied through some kind of conditions or undertakings. As competition authorities, we have approved the consolidation of platforms. If you think about Facebook, Twitter, these are probably the most foremost kind of social media platforms that could potentially compete. In fact, I still think they do somehow. People choose these two and as though they are competing. But we all know that we allowed that transaction, and who knows what would have happened had these two been allowed to kind of develop side by side as competitors. We've allowed SAB InBev merger. In fact, this merger also illustrates how inward-looking countries are when they look at transactions, because everybody kind of recognized that there was a problem with concentration in the beer market. There's nobody who didn't recognize this. But everybody went to look at their own particular countries, and they looked at which brands could be diversified to try and kind of mitigate this sort of thing. We have had a series of measures in the food value chains. In fact, there's a study that was led by one of the panelists here, Ioannis, that clearly shows that there is a problem. You know, there's no doubt that the consolidation in the major value food chains is a problem, particularly for countries that are at the receiving end, countries that don't own the technology, that are buying a lot of the products from these companies. But again, the message coming from antitrust authorities was that this is not a problem that's too big and that could not be remedied by conditions. So there is no doubt that increasingly competition authorities are under pressure. And I think it's a well-deserved pressure. I think it is right that competition authorities should be under pressure for these and many other decisions, because I think, you know, there's a responsibility that we have. We can't say that, well, we've defined markets differently and that's why we allowed concentration. So I think the result of this, and this is really my main point, even if I keep quiet after this, the result of this is we're kind of losing legitimacy. And you'll understand this from a developing country point of view that, in fact, competition authorities are a fairly new phenomenon. Their legitimacy is always going to be questioned. What is their role in development and so forth? And so when you have all of these problems, what you're asking for is a political intervention. If competition authorities cannot solve the problems, then the politicians have a right to say that we will then solve it. In fact, you hear this noise also in developed countries nowadays. In the UK, you hear a lot of stuff about public interest and so on. So the failure to address this problem, I think, suggests that we have to review the mechanisms that are there, including the mechanisms for global cooperation. I'm certainly hoping that within BRICS we can do a lot of work in terms of looking at these, because one of the problems is you can't really block a mega major alone. It's almost impossible if you are a small developing country. So I think that there's a need for joining forces, so to speak, in looking at these better cooperation on remedies, for an example. I think a lot can be achieved with these. I also think that, and there are many transactions, I mean, we now are all looking at Siemens Alstom, which is another mega major before many authorities. And I think it's going to be interesting to see how, again, this global cooperation leads us to. And the final point I want to make is that, you know, of course, developing countries also have an inherent disadvantage that because they are small, the firms are becoming too powerful. So there is an issue of whether smaller countries are going to be able to regulate this type of economy that's emerging out of these mega majors. So I think that we can't escape, again, the political question that is a consequence of global concentration. And so, once more, if we fail to address these problems, I think that they are going to lead to more interventions. One of the things that are, for example, included in the changes in the South African competition law now, courtesy of, I think, the United States, is that we now are going to have national security provisions within the law. And so what happens elsewhere in the world does matter in terms of how the kind of politics of regulation pan out in many different parts of the world. And I think there is a special responsibility on the larger jurisdictions in this regard, including the kinds of decisions we make in mergers. So I'll stop there. I was going to talk about public interest, but maybe we'll come back later on that. Thank you.
Gönenç.
Thank you. So an interesting discussion in the emerging markets context is, I think, that ultimately not only should we see that the antitrust regime in general has to exclude policy objectives, goals that don't belong to this field, such as the protection of the small enterprises just because they're small, or such as protection of competitors but not competition, such as inflation policing and fighting with increases in price, such as protection of the environment or general public good in the form of health and all. These are very valid policy objectives, but they don't belong to the competition law field. Another thing that we need to be vigilant, especially in the emerging markets now, is the impact of a particular development in a policy objective that actually does belong to competition law, which is fostering of innovation. Now, dynamic efficiencies obviously are a part of the equilibrium because distributive efficiencies and cost efficiencies are an important source of economic efficiency in general, and therefore the chance to maximize welfare. The same happens to be true for innovative efficiencies, dynamic efficiencies even more so. It's probably correct to say that dynamic efficiencies are the biggest engine of welfare maximization. However, the way this is being pursued in the more mature competition law regimes, unfortunately, is leading to a result in the emerging markets that the emerging markets may be paying lip service to innovative efficiencies and they may be actually engaging in perverse enforcement under the banner of protecting innovation. If I were to, let's test this, if I were to tell you that as of this morning, the Mexican Competition Authority and the Turkish Competition Authority and the South African Competition Authority and the Brazilian Competition Authority have all decided that they're going to use a significant impediment to effective competition test from now on all mergers, and that they're going to engage in innovation analyses in mergers that lend themselves to this analysis. A lot of you would be taken aback, and a lot of you would be thinking, well, one, these are not jurisdictions that are originating that innovation, so this is bothering me a little bit because they shouldn't be taking the lead in the sense that there could be an erroneous analysis here. And two, do they have the economic analysis tools and equipment to deal with this issue? Now, the problem is that it seems the European Union does not have the appetite to engage in the same factual economic analysis that is required for these kinds of analysis either. It seems they're just throwing at us literature and theory. I'm not belittling literature and theory, they're very important, but untested literature and untested theory, and they are going after a theory of harm very easily with leaps of faith. Now, when that's happening in the European Union, you can assume that the inspirations of that in the emerging markets can be very dangerous in the sense that then a lot of agencies may also engage in untested theories of innovation, especially with the same types of reflexes that we see with the more mature antitrust agencies. The reflex that they actually do use the traditional reflexes, i.e. market power issues, concentration ratios, what does this do to distributive efficiency in the form of price increases? And then when they're ticked off by it, the secondary supportive line of argumentation against the transaction would be innovation issues. So innovation issues are never really evaluated within their own right, but they are actually supportive troops of raising problems. When that's the case, we may start seeing emerging markets, and we're certainly seeing it in a couple of those. We may see emerging market competition authorities paying lip service to innovation at times, or actually making points on innovation that are going to make their way into the precedents. Nevertheless, unfortunately, whenever it is time to hear innovation defenses as such, they would be deaf to it. So when it is time to raise a concern, and when it is time to make it an issue, innovation would then become visible to the antitrust agencies. But whenever it is a defense in favor of a transaction, when it's presented as a countervailing factor of traditional competition law worries, then it may fall on deaf ears. The same may happen on the use of standards of proof as well, in the sense that it seems right now The standards of proof that are used with the more mature agencies in the world are standards of proof that don't really allow for the budding discovery phase innovation to be demonstrated to the agencies. The agencies almost are comfortable with the notion that they don't exist. Whereas we all know that without budding innovation and discovery phase innovation, all of this innovation that is happening more and more cannot possibly happen. However, we're constantly turning a blind eye on the existence of these. This is quite concerning, especially when you see the way the world is changing. In 1996, Richard Rapp in Antitrust Law Journal has said, innovation is intangible, uncertain, unmeasurable, and often even unobservable, except in retrospect. It is unfortunate that some 25 years almost have passed, and this sentence could have been written just yesterday, and we wouldn't be criticizing it, so we haven't demystified innovation at all. On the other hand, when this sentence was written, there were 16 million users of internet in total in the world. And today, when there's a Facebook disaster, it leads to 90 million people being impacted, and there are 4 billion users of the internet. And the entire market has changed entirely into the digitalization and all that. So I contend, therefore, that we keep on using the same hammer, but the nail has changed so dramatically that we're now at the crossroads of either recognizing that we need to engage in factual economic analysis that is warranted by the given case at hand, which is a technology that will exclude emerging markets authorities for a while and for good, or we will start paying lip service to innovation, and we will start hijacking the concept for traditional reflexes' sake, in which case the emerging markets will also jump on the bandwagon, and it's going to be very difficult to then sanitize the process. Thank you.
Okay. Good morning, or whatever time it is. I want to start by making a comment about my sense of what's happening in the review of mega mergers around the world. And to me, and the first panel talked about that, the review of mega mergers is becoming absolutely less doctrinal. And that is not just in antitrust, because, and I'm going to talk about the other types of reviews that are taking place, and I want to quote, not that Business Week is the Bible of everything truthful, but a quote from an article in the Business Week of October 1st. So from Beijing to Brussels, government are treating corporate mergers as weapons of industrial policy. Deals that may have passed muster on competition grounds are being weighed and increasingly thwarted for the risks they may pose to a country's security and strategic industries. And it goes on to say, and this is an article mainly about changes in CFIUS in the United States and what the EU is doing, but it says, in reality, these changes reflect a new consensus in the US and Europe that takeover controls designed to enshrine competition are outdated in a world in which sovereign ambition relies on business as much as it does on battalions. So what we are seeing here, in my view, is that we're having a proliferation of merger reviews around the world, which is an amazing accomplishment, if you think about it. When I first went to the OECD representing Canada in the 80s, there were basically like 2 or 3 countries in the world that had merger review. Now we have well over 100. And that has brought about, of course, the debate we're having here about how broad those tests are, how opaque the decision-making process is, how lack of conformity is on timelines, how there may be not effective accountability legally in some jurisdictions. But at the same time, we are seeing not just emerging countries, but we're seeing the developed world introduce new forms of merger review, whether for industrial policy or public interest or national security, as a way of imposing restraints or at least the ability to review mega mergers. And that trend, in my view, is not the trend is obvious, and more countries are adopting these measures. And I can tell you from a country that has had a broad foreign investment review regime since the 70s, started out because we were terrified of the Americans taking over the economy. Now we're worried about other people, but we have incorporated a national security process in addition to our broad public interest test for foreign investment in Canada, and ultimately, certainly on the foreign investment public interest side, it ultimately, in Canada at least, is a political decision. There is no there there. It is entirely ultimately driven as a safety valve for the government of the day if a merger does not seem to be politically popular. And national security reviews in Canada are becoming increasingly difficult. Talk about opaque. One has no idea what the problem is that you're trying to address. And so these issues are not issues just in emerging economies. In my view, this trend and these issues that we're facing in mega mergers review are quite broad, extend well beyond antitrust. Some antitrust regimes obviously have public interest tests which incorporate this. But the issue that it raises for me, if this trend continues, and by the way, I think you're seeing signs in the US, who was the bastion and supposedly taught us the importance of the consumer welfare standard, that there's more political interference in some decisions from the Antitrust Division in particular. But the issue that raises for me is, where is convergence heading in this world then? Because that was what we were trying to do. That was the whole purpose of the ICN, which was a much broader forum than the OECD. And so where is that heading? Now, secondly, I want to talk a little bit about mergers remedies, and remedies in particular in emerging economies. I do agree with my friend from South Africa that I think by and large it's difficult for emerging economies to say no to a merger. But it does open up another front, which is on the remedial side. And I've certainly been involved in a couple of mergers in the last couple of years where I thought that the remedies that were being sought were certainly not in conformity with what the ICN guideline on remedies says. And I'll read to you from it. And by the way, I'll read a comment there, which people can, antitrust authorities in emerging markets can rely on, I suppose. It says, for multi-jurisdictional mergers involving international cooperation, each competition authority should exercise its independent judgment in reaching its enforcement decisions regarding the need for a remedy. So it basically recognizes that these are sovereign countries and they have their own law and they have to apply it. But when it talks about what the remedy should be, it says, to be effective, remedies must resolve the competition concerns the merger gives rise to so that competition can be maintained or restored in the market. Tailoring the remedy to the harm allows competition authorities to require the least intrusive remedy without compromising effectiveness. And that is certainly the law in Canada. Our Supreme Court of Canada has basically taken that view that in a remedy for a merger, the object of the remedy is to remove the substantial lessening of competition, which is our test. It is not to put you in the status quo ante, and it certainly isn't to deal with some concern you have about the state of the competition before the merger. But my observation of what I've seen in some emerging economies is that and maybe it's because they don't feel they have the ability to sort of stop the merger, that there's a tendency to use the remedial side of it, apart from sort of the legality of the harm, to bring about a change in competition which is unrelated to the merger. And that, to me, is a problem, particularly if we believe in convergence. Now, I wanted to refer a little bit to the work and the speech that the Assistant Attorney General gave on June 1st about an attempt by the United States to move towards more convergence on procedures and process. But one of the things he said in that speech, and I want to lead to a sort of probably a provocative and unacceptable idea, but he said the compliance mechanisms, and he was talking about compliance with any arrangement on procedures, and it could apply to substantive standards as well. The compliance mechanisms do not envisage establishing a formal or binding dispute settlement mechanism, but do help to ensure that we have sufficient incentives to comply with the common requirements. And then he goes on to says, and one of the factors that they want to focus on in particular, because there are a number of different ways you might do that, is a way to enhance reputation of the agencies, which I think is an interesting idea and which, to be honest, one I share. But then he also says, and I want to come back to this when I talk about sort of what we might do about this, accordingly, our goal, and this is the U.S. Antitrust Division, has been to design a respectful agency-to-agency arrangement that is not a treaty in the formal sense, but nevertheless uniquely suited for the specific functions of market competition and enforcement competition authorities engaging. So my question is, if we are in this world where we still want to have convergence, and we have ICN guidelines, which people have signed on to, how do we ensure that what do we have to do beyond just publishing these things to try to make sure that there is some accountability there? Now, one thought I had, and I think some authorities are talking about things like this, is should we have an opportunity for ex post reviews of these situations where people think there's that maybe they haven't conformed to the guidelines. Maybe those reviews are in private. There's a question of who does it. Is it a peer review exercise? Is there an opportunity for the private sector to ask for or require such a review? And if so, who would do it? I mean, should the ICN become a more formal organization than it already is? Because I do think that if we're coming to the point where if we do not do something to ensure compliance with these guidelines, that they're not worth the paper they're written on. And I think, given the way in which, as I said at the beginning, that the review of mega mergers is becoming less doctrinal, which is a charitable way to say that we are giving essentially unfettered discretion to governments or agencies, then the whole notion of is there any role for convergence, I think, is in serious jeopardy. And now, the last thing I want to say is how do countries, and that obviously includes how do the private sector parties involved, and because they may have their home jurisdiction. Sometimes they wouldn't, obviously, if they're large corporations. But what is going to be the role of the home government if there is a concern with the treatment that a merger is getting in another country? Now, I've recently been involved in a few cases, and in fact, I was confronted with this. We went to the Canadian Competition Authority and said, we think that the way this merger is being treated in this jurisdiction does not conform to the standards that apply in the ICN guidelines, and we would like you, as the antitrust agency, to intervene with your sister agency in another jurisdiction and point this out. Now, to be honest, just to be clear here, we didn't dare ask them until they'd cleared it in our jurisdiction, because that would look a little weird. But we got turned down. I think there's a great reluctance by antitrust agencies to interfere in each other's backyard, partly because they say, well, if I do it to them, then they're going to do it to me, and would I want that to happen? But I was asked, by the way, by the head of the Antitrust Authority in Canada, well, this never happened? I said, oh, yes, it did. When I was the head of the Canadian Competition Authority, I did intervene, particularly in Europe, on a particular case, because I thought the way the case was being handled was inappropriate. So there's a question for me about should there be some way in which the antitrust authorities themselves can be more open about commenting on cases in other jurisdictions. And I guess my sense is if they will not, and if we are moving into this world where where we're having very broad, less doctrinal reviews of mergers, then we are really going to open this up, and maybe we should, to a government-to-government, sort of a PR, GR, diplomatic type of involvement of governments in merger reviews. And that is, in my view, which we've tried to prevent, is going to necessarily politicize the antitrust enforcement side, which I don't think is a good idea. So I think we've got to figure out where can we move convergence in light of these trends, which in my view are, in mega mergers, away from a very doctrinal antitrust standard alone.
Well, thank you. I agree with so much of what's been said. I will try not to repeat. It seems to me we're at a really fascinating juncture. Having created this great world of agency enforcement of merger control that I'll say a word about in a second, we've achieved a certain consensus and consistency if you look back over 25, 30 years. And I think the questions that we're talking about today and that we're all thinking about are whether that consensus over the right legal standards and the relevant criteria are going to hold, are they sufficient, or whether that delicate consensus that has been quite difficult to achieve is going to survive the Trumpian assault on international collaboration and lead to a more transactional model with each country, in a sense, looking after its own interests and using merger control broadly defined to include industrial policy or national security or the whole process of vetting and considering transactions in a way that's not previously been anticipated. So let's start just with this explosion of merger control that's been talked about. I started my career a little after my Canadian colleague, but even when I began, there were only 4 or 5 agencies around the world, and now there are over 130. You see, as we've heard, many transactions now being subject to 20, 25, 30 reviews around the world. Back-of-envelope calculations suggest in any 1 year now there are almost 10,000 notifications being filed around the world, very many of them, for obvious reasons, of essentially the same transactions. When I began, you could typically predict you get approval in most countries within about 5 to 6 months. We're now talking about 12 to 18 months at costs of tens of millions of dollars. Now, of course, it's very hard to object to any country having its own system of merger control. On the contrary, it's to be applauded, and the fact that every country with a flag now has a merger regime is a great success. I think it would also be wrong and ungracious not to recognize and applaud the incredible advance in sophistication of the great majority of developing market agencies. Indeed, I think you might argue that they have evolved faster than some agencies, including the European Commission perhaps, evolved over its own history. And during this 25, 30 years of explosion, we've had all sorts of concerns, I think, in the community. Concerns about divergent jurisdictional criteria, which continue to be a bane of practitioners' lives, concern about procedural divergences, and concerns most fundamentally, I think, about whether there were going to be material substantive divergences. Were you going to see transactions being approved in some countries and blocked in others, or the remedies being inconsistent and so forth. And it turns out that we were wrong, I think, in at least 2 respects, and it was an achievement of the OECD under Fred's leadership and the ICN and others, and I think the increasing maturation of emerging market agencies that we were wrong. The 2 respects we were wrong, I think, was that we haven't seen the inconsistency in substantive appraisal that people thought we might. In fact, if anything, as we've heard today, developing market agencies have been somewhat deferential towards the United States and the EC. But we were also wrong, I think, because we missed what seems to have been the bigger story, which has been a perception, and I echo what our South African colleague said, of overly indulgent enforcement. That maybe agencies around the world have been too permissive. Again, I speak as a student rather than a practitioner. And the question we now face is has the pendulum swung too far in the direction of almost creating a presumption in favor of mergers? So the critical question that I ask myself when I look at all of this merger activity, this whole world that's been created, is whether it's actually led to more effective control in developed and developing countries. I think that should be the key question that we ask ourselves. Are the outcomes we're seeing now better as a result? Is the cost and the delay and the frustration worthwhile? And again, speaking as a student, I'm not so sure. I think companies are frustrated by the cost and the delay. Developing country agencies may be frustrated to hear one of the world's leading industrial economists say that perhaps they shouldn't have been following US doctrine quite so assiduously over the last 2 decades. And also, as we've heard from our South African colleague, they may be frustrated by their perceived inability to play a meaningful role in cases where global mergers are reported in their countries, and see their role as being limited to analyzing catchment areas for cement plants, say in the Lafarge-Holcim case, or aggregation of beer brands in the AB InBev case. And policymakers and legislators now seem frustrated in what they view as being suboptimal market structures that have been created under their watch as a result of what they may now consider to be overly permissive merger control. So what to do? How to deal with the situation we now find ourselves in a way that does not jeopardize so much of what's been achieved, create uncertainty and inconsistency and divergence that would be unhealthy. And I have 4 or 5 thoughts, none perhaps particularly original. I certainly echo the view that greater coordination is desirable to avoid duplication, to reduce unnecessary delay. In some cases, it may result in some agencies effectively ceding jurisdiction to review transactions to others, just to avoid the excessive duplication of similar kinds of reviews of the same sort of issues around the world. In others, it may lead to some of the lead agencies taking on board concerns of developing market agencies in their own reviews. Secondly, I think the answer, if there is a concern about overly permissive merger control, is to appoint agencies and empower agencies to be more interventionist. I'm not sure I quite share Professor Stigler's view that change necessarily requires a complete overhaul of the law, if that's what he was implying, or necessarily replacing economists with new economists or changing the guidelines or so forth. It may just at the end of the day require agencies to be readier to say no. We have concerns about this merger, and to remove some of the stigma that surrounds a decision not to allow a transaction to proceed. Third thing I'd say is this whole debate about industrial policy and injecting political or quasi-political criteria into the merger process. I have some skepticism about it. I'm not sure antitrust agencies are particularly well suited to doing a lot of what's being suggested. I think ultimately these decisions are really political ones, and if a particular country wants to pursue a political objective, I think it should, but it's the responsibility probably of the politicians to do that. There's obviously great scope for getting things wrong, but I think fundamentally when you see these sorts of questions from a competition perspective, very often what you're talking about is trading off some reduction in competition against some perceived benefit in terms of employment or some other public interest advantage. So it's not necessarily obvious to me that the injection of some of these additional criteria into the antitrust process is necessarily going to result in more competition. It may indeed result in less, which doesn't seem the objective that's being sought. And finally, I think that there are things that agencies can do beyond those that they currently do if they're concerned about structures. And just from the UK perspective, one of the instruments the agency has is the possibility to investigate an entire industry, a set of practices within that industry if it's concerned that that industry is not functioning well. It's done that in the airports, in the banking, in the energy, in the cement sector, with varying degrees of success. I will stop there.
Thanks. Ioannis.
Harry, thank you. And as you mentioned before, you put me at your extreme right. We have the Woodstock antitrust, the hipster antitrust, the Bannon antitrust now. But from a point of view of the audience, I'm the extreme left. So I don't know exactly what you had in mind. But anyway, thank you very much. So what actually I would like to discuss is a little bit from a descriptive perspective, what is really happening. And I think for the time being, when we think and talk about merger control, we have in mind this kind of regulatory model, in a way that the competition authority assesses how the merger may significantly lessen competition or some other criterion that it has, looking to countervailing efficiency gains that may neutralize the effect on consumers or total welfare. And the idea is that there is a public interest form of regulation, narrowly constructed to mean consumer welfare. And obviously, we focus very much on the independence of competition authorities, also from other parts of the government, and we put emphasis on adjudication and evidence-based decision-making. But what I'm actually asking myself, is this really what is happening? Does this really, this regulatory approach, the way we think about the regulatory model of merger control, reflect modern merger control, in particular with regard to mega mergers? Can it actually operate descriptively and normatively in this case? And I will not spend here too much time to discuss about what is a mega merger. I mean, Harry gave some figures. Is there a particular threshold? But my understanding would be that what is a mega merger might depend on the competition authority that looks to it. So what might be a mega merger for the competition authority of Turkey is not probably the same than a mega merger from the US perspective. But I think from my perspective, there are quite two important things that have somehow changed. So the first one is the increase of the number of competition authorities. Now, if we look to the literature, in particular the OECD, in a report that they did on challenges of international cooperation in 2004, they basically created an index of complexity index, as they call it, and they said that the last 20 years, the cooperation complexity index for merger deals has increased by about 23 times. To a certain extent, criticizing probably the fact that we have now, and as the previous speakers mentioned, a quite important number of competition authorities to which the mergers have to be notified. But actually, in reality, if we look to that, we also heard that very few of these competition authorities have the power to block the merger. And most of the mergers are actually approved or conditionally cleared, with a number of those authorities rubber stamping more or less the merger. So that's the first element. The second is economic concentration, which I think has increased considerably, and we heard this morning from Jill Stiglitz. And I was actually looking to a recent post of the World Bank. It's called the World's Top 100 Economies, 31 countries, 69 corporations, where basically they list the most important from an economic perspective, power in terms of revenue in US billion of dollars in 2017. And actually, if you look to the most important economic centers, Indeed, there are very few countries and actually quite a lot of corporations. And this particular blog hasn't looked also to the importance of institutional investors or asset managers in the global economy. If we look to BlackRock, for instance, they manage assets of around $6.2 trillion US dollars in 2017. This would place them immediately after US and China as the third, maybe the EU if it's considered as a jurisdiction, as the third economic power in the world. So I'm aware this is kind of simplistic, but when you think about these mega mergers between these corporations from one side and the other countries, the emerging economies or developing countries or smaller economies from the other side, I think that the regulatory model of merger control that we have been somehow thinking doesn't really work. And I would say what really is happening is more of a bargaining type of model. I would say that the idea is that the emerging economies, they know that they can't block the merger, so what they try to do is to get at least the best outcome of the situation by basically bargaining with the merged companies and trying somehow through the remedial process to get some benefits for their stakeholders. So I think if you're changing from a regulatory model to a bargaining model, I mean that has implications with regards to the way you think about remedies and the way you think about public interest tests, and I will discuss about those later. But I would just want to mention a little bit about the bargaining model. So there is actually a lot of literature with regards to international investment and multinational corporations and states, and the so-called political bargaining model, where basically you have a sort of iterative political bargains between the multinational corporations and the governments that is happening. And I think to a certain extent we might apply these models in the context of the specific type of merger control. And they're quite interesting two-tier bargaining models where basically they include also this, the point that was mentioned before by one of the speakers concerning what is the home country of these corporations do, what they do. And in this two-tier model, actually, they define, they separate two steps. So the first tier one bargaining is happening between the developing countries' host governments and the developed countries' home governments. And again, this doesn't necessarily take a very active intervention from the point of view of the competition authority of the developed country calling, the developing country and saying, please get this merger approved. But it actually might take more indirect, basically, approaches like, developing bilateral, multilateral agreements or organizations that are inspired by certain, idea of convergence that they then, somehow put forward some argument against anything different from that particular convergent model, actually, to the developing country. So it can actually be much more indirect form of influence that we might have. And obviously, at the second tier, there is a bargaining between the multinational corporations that want to merge from one side and the governments from the other side. And I don't want to, I'll probably mention later what are the implications of, if we think of a merger control system as a bargaining, basically, model rather than as a, regulatory type of decision for remedies and also for the role of the public interest. But to a certain extent, I would say that if you are an emerging or a developing country in this world of economic concentration, what you really try to do is to somehow increase your bargaining power, basically showing that you have better alternatives in your disposal so that you can actually block the merger. So, and from that perspective, the strategies that emerging economies and developing economies may have might be very different from what actually we might think in case we develop the classic, regulatory model. So I'll mention a few examples later, but I just wanted to start with that.
Okay, so thanks to everyone on the panel. A lot of intriguing questions to me. So I want to start actually between first and the last. So I was intrigued when Tembi said, well, of course, we can't block any of these mergers. These are all going to be allowed. And I thought, well, from the point of view of global consumer welfare, if no one can block them, but they should be blocked, something's wrong. And then I'll take Ioannis's descriptive notion of a bargaining process and then put this hypothetical to the panel. So suppose the 5 BRICS countries decided to merge their merger review, all right? So they decided that for very large transactions where no one apparently has enough power to stop them, they agree to have a single merger authority which would review the transaction. And they'd have you can figure out how they would do it. So would that solve a lot of the problems that we see here? Would that be a good idea? Is this just in these huge mergers with multinational corporations, the bargaining power is distorted, sort of abusive dominance vis-a-vis the agencies. So maybe they should merge. So I'll, any reactions from the panelists as to whether that's a good idea? So Tembi, you want to start?
Yeah, I mean, it is, of course, a troubling proposition to say that we can't block a merger because by law we can. But I think there is also an acknowledgement that there is such a thing as momentum in mergers. So once you have a critical mass of approvals, you can't stand against the tide. Particularly if you are small. If you are big, maybe you can. Firstly, the leading jurisdictions in the world have a special responsibility when it comes to that, because once they create the momentum, it's kind of difficult to stop. So the first thing is just that we need to now look at the timing, for an example, because often the strategy of the firms is to notify at different times, and they manage all of this, and they are leading counsel even here in the panel. But I think this is quite transparent if you are sitting in a sort of competition authority, that the notification themselves are not just a random exercise. They are very well planned to achieve this kind of momentum. So that's just the first proposition I would want to make, is that, I think part of reviewing how we are working is also looking at the timelines. And as the system evolves, I think we need to kind of, I don't think we can harmonize the standards to a point, but I think at least we can harmonize the timelines and things like that, that enable a conversation to take place. But I also think that what would strengthen developing countries is not just to maybe, I think that's too far to say you match the authorities, but certainly I think they can work and coordinate together. The starting point, of course, is sharing just understanding of these markets, knowledge, research, and the capacity within agencies. We've started with some of these, but I think that needs to be elevated into discussions about the decisions to be made. Do you block, for an example? I think that we need to get there. We need to be able to block measures. And I agree with you that if we do it jointly, it's certainly going to be much more manageable. I think if we had looked at the food measures, at the food value chains together, I think there is a chance that some of those measures could have been blocked, because I accept that maybe they didn't pose as much problems in countries like the US and the EU, but they certainly were a huge problems for emerging economies. So you don't have to match, but you can certainly work together. And also in regions, in Africa, for an example, I think there is a case that you you maybe can better look at measures jointly in the continent rather than as individual countries. Firstly, there's too many countries, many are too small, many may not even have the capacity. So I think all of these regional initiatives are going to be quite important for the future if developing countries have to play a meaningful role in regulation.
We'll go down the panel here.
Okay, so okay. First, a disclaimer. I'm an attorney, and I have done.
Okay, that's enough.
Yeah, and I've done about 300 merger control filings, and Bayer Monsanto is a file of mine. Dow DuPont is, ABI Sabmiller is, ChemChina, Syngenta, Luxottica, Essilor, all of these, which means I may be a bit biased, but I don't believe that it would be a correct statement to say that the antitrust agencies are overly permissive. Maybe in the well-developed antitrust agencies we could discuss this, but in terms of what Tembi has said at the very beginning, we don't say no. I don't believe that that's exactly the case, at least in my 20 years of experience as an attorney. That's not how I have seen it. How I see it is the antitrust agencies know that the parties don't say no. So investment bankers are a particular interesting breed of human beings. They don't know how to say no. So these deal-making people, they try to make the deal. They will make the deal. And when you have that kind of an environment, even if you were to see certain remedies that are striking the parties in the heart, and they're honestly in teleconferences to us are saying this is insane, this is outrageous, they will still find a way of taking that oomph and still proceeding with the transaction. The fact that there has not been a strike down rejection kind of a decision, therefore does not necessarily mean that the merger control analysis does not have teeth. It's a game of remedification now, and there are a lot of remedies flying around. When the R&D line and the pesticide business was divested in Dow DuPont, it wasn't that the CEOs deciding about it wanted us to give them summaries of the 915-pager decision by the European Commission. It was a very quick question of what do we need to do to make this deal still happen. So we might be a bit, looking at it from not exactly this right direction when we make rejections the proxy of whether merger control is working or not. Rejections are something to be avoided. Ultimately, rejections are not a good thing. And if two parties of a transaction came together and wanted to do a deal, there has to be an inherent assumption of some form of efficiencies coming about from those transactions. I'm not saying there has to be a deference to it all the time. All I'm saying is a rejection should be a last resort. Therefore, I think I'd say that, going back to the hypothetical, even if the BRICS antitrust agencies were to come together, they would be a better antitrust agency only to the extent they are communicating better in terms of issue spotting, which is actually a need in the world right now. So it does frequently happen that an antitrust agency gives a phase one clearance, although there's quite a bit of concentration going on in that jurisdiction, and then another antitrust agency raises a flag and makes it fall into a phase two. The first antitrust agency feels, ooh, I should have done this as well. Actually, I have gotten them too much slack. An even worse HHI index is seen in my jurisdiction. Now I'm going to be seen as not doing my homework and all that. So when taking issues and when raising a flag, I think more communication would make life better also for the private practitioners. And the same with remedification as well. It would avoid redundant remedies being produced into different files. It would mean that we could go about presenting one set of remedies to one jurisdiction, and all the affected other jurisdictions can do their own analysis and wouldn't want the same remedy to be produced into their files and all that. But long story short, I feel that the merger control analysis may have its flaws, but ultimately whether it works is not a function of whether there are enough rejections around. Especially South Africa, to my left, you have the commissioner, is a jurisdiction where you do see that a lot of players are getting out of their way to accommodate the agency. There are employment requirements that are articulated, requirements that are not particularly known as competition law per se related matters. So there are, public good arguments that are happening in the review of some of the agencies, and I think they are also accommodating these requests because they feel they have to have these transactions go through. So it's a game of whatever one can bite and chew rather than what one can reject. And my fear is that if there were to be the power to actually reject a global transaction, it wouldn't be used to globally reject the transaction. It would be used to bite something more and chew more.
I'll be very quick. We have to remember that merger review in many, many countries is a pretty recent phenomenon. And so I wouldn't count on agencies around the world not feeling like they can reject mergers. And I think they do. I think the larger jurisdictions already have that power and have done so in some cases, and I think that's going to continue. But I do think there's a sense of proportionality, and that leads into what you mentioned, what I mentioned, what Ioannis mentioned, that it moves you more into the remedial side of things, where there may be extracted remedies that are not what one would normally be seen of as flowing from the harm to competition or from an antitrust issue. And so that's why I think we need to pay more attention to what's happening on the remedial side and what's happening on a conversion side. And I guess finally, if my conclusion about the trends of the less doctrinal merger review, then I think more and more countries are going to say, yes, we do have the ability to say no. And so I don't think we should count on this being an environment where only 2 or 3 jurisdictions have the right to say no.
I agree with that. I'll be very brief. I think that is right. Obviously, I think if you did combine a number of agencies into one, I guess they would have more heft. We know that's not going to happen. It's also inconsistent with this other trend we're observing of each jurisdiction trying to look for the opportunity to get some advantage on on some other front, whether it's employment or national security or what have you, that they would merge into one. More coordination has to be a good thing. I was actually surprised to hear from the South African panelists that they didn't think they could block mergers. It certainly doesn't feel like that when you're doing one of these cases.
Exactly.
So who does have the power here?
It feels like everyone has the power except you. I also like to disabuse him that we on the private practitioner side have this well-oiled machine with a great sort of Excel sheet on our walls, and we're choreographing all of the filings to get the best outcome. These things are long and hard and brutal. They go on for about 12 to 18 months, and even if we could choreograph it, it would be a super slow dance.
And the damn investment bankers, they only want to get paid, and they only get paid if the deal gets done, so they have a great incentive to make a deal.
I guess we don't have any investment bankers here. Okay, so Ioannis, then we have 2 seconds for questions.
Yeah, coming back a little bit to this bargaining approach. So basically, I think we need to understand that the bargaining power in this context is going to be assessed according to what is the best alternative that you might have, right? So for the, and that is, you have to assess it from both the point of view of the state and also from the point of view of the multinational corporation. So the EU and the US, I mean, they actually can block a merger, and they have the ability to do so, and obviously the corporations know that, and they're ready to compromise there and provide part of the joint surplus that actually might be generated by this merger. What I think is happening with the merger in developing countries is that even if you say that theoretically they can block, they are not really capable in terms of law, because in case they do, well, the best, I mean, they're not going to have a next best alternative, because they might say, you know, the merged corporations might say, okay, fine, we are actually leaving you out of the transaction. So from my perspective, what you need to do in this case is to somehow enable the developing and emerging economies to increase their outside options, their next best alternatives. And the way to do that, I think, is through some form of cooperation. I mean, the BRICS cooperation in this case is very important, and we're going to hear about the new BRICS Competition Law Center that has been put in place, and there has been also the idea of creating some form of consortium which will somehow deal with some of these type of evidence, basically gathering evidence assessment issues. So I think that is going to help quite a lot to increase the outside options of the developing emerging economies, and that make them more credible when they say, oh, we can block the transaction, because they will see, okay, they have the ability to block the transaction. And I think the second issue that this cooperation might resolve, which is another source of bargaining power for the corporation in the bargaining process, is the fact that there's asymmetry of information here. I mean, so and when there's merger, because of the fact that, you know, there are different timelines, the companies, when they merge, they choose very strategically to which authority they will notify first. There are waivers in terms of, you know, the exchange of information between the various authorities. So I think that that provides them some symmetry of information, because basically competition authorities have a very limited amount of time to take a decision and to analyze the merge and collect this information. They depend really on the information provided to them by the merged companies. And I think in this case, I think we might help having this kind of cooperation like the BRICS or this consortium, where you have information exchange between the competition authorities, and, you know, even about confidential information. And I think we have at the global scale, you know, we have Section F of the UN set. Of course, it's very controversial. There are actually a number of agreements. There's a memorandum of understanding between BRICS authorities. It doesn't cover confidential information. But I think if we develop this kind of cooperation between emerging and developing countries with regards to the exchange of information, that might reduce the bargaining power that comes out of the asymmetry of information that exists between merged companies and the states in this bargaining game. And final point I will say is that the public interest test, and even, you know, what Ioannis mentioned before about innovation, I see them also as a tool, basically, to reinforce your bargaining power in that bargaining game. Because basically, one might think of the public interest as a kind of a commitment tactic that might be used by the states. They know that they're outgunned by the experts of the merged companies with regards to just focusing on consumer welfare and economic analysis. It reduces their policy discretion by having something which is a little bit fuzzy, like the public interest test, or, you know, focusing on innovation. In fact, that actually, which is still not from an economic perspective very settled in terms of what type of test you're. I mean, there's a divergence here between the US and the EU. That offers them a little bit more policy space that they can use in this bargaining game. So, one might think that this is why they are very much. Some of them, at least, are very committed to this public interest test, not necessarily because of the fact that they think that the goals of competition are broader, etc., but also as a tool in that bargaining process, because it gives us basically more power to a certain extent as a commitment tactic, basically. So I would say, you know, we need really to think of these mega mergers, I think from that bargaining perspective. That will help us quite a lot to understand what is really happening. But that's a descriptive theory. I'm not saying that this is exactly what should happen. It's not normative. It's basically descriptive. I think it explains better what is happening.
So all of these things from the point of view of a developing country can be a tool to improve their position, or from the point of view of the merging parties, a lever to extract more as sort of a merger test. And what you may think of that may depend on where you sit. So we have no more time, but now I'm going to take questions. Eddie, I'll take one or two questions, but I'll tell you that lunch will be served right afterwards. So first question here, I'll take one more, and that'll be it, and then the panelists can respond. Yes. Sorry, yes. You're getting a...
Hello, my name is Sarah Kim. My question is, what do you think are important and concerning implications of increasing mega mergers on inclusive and sustainable growth and public interest, as you define it, at the global level? And how do you think we should manage those implications?
All right.
Okay, so that's 1 hour. It's a great question, though. It really goes to the heart of what we're talking about. There was one person back there. I can't see from.
I'm not an investment banker now, but I was an investment banker.
Your confessions of a
And
four-hour.
one of the things that you haven't raised, and which struck me, is that you assume that these mergers are uncontested. And then certainly in a contested merger, you would have investment bankers on opposite sides who might try to use the competition or other kinds of regulations in order to have their opponent knocked out. So I wouldn't, so you would have experts coming in on both sides, or maybe even more than one if you have even maybe three, if it's a particularly desirable piece of property or a particularly desirable merger. You might have people you might have even 3 or 4 situations. And some of these can be very big. If we look at, for instance, Comcast trying to acquire, Disney competing to acquire Fox News, and also the interest in Sky. I mean, and clearly they were using UK competition policies and regulations in order to favor, in that particular case, Comcast. So I think that you can't just assume that it's straightforward, but how do you handle situations which are highly contested?
So complexifying the bargaining game. So reactions to either or both sustainable growth issues and how this plays in, and the complexity of contested offers. Anybody?
If you want, I can take on the.
Okay, yeah, sure, yeah.
So it is true that we see in private practice quite a bit the landscape changing according to the regulatory landscape changing, so the transactional and the negotiation landscape changing according to the regulatory landscape changing, and especially when there's a signaling of a phase 2 investigation or that things are becoming more complex, it is true that parties start flexing their muscle, especially if there's a hell or high water kind of a clause in the share purchase agreement. And that is very interesting also for the competition law practitioner, because then you start getting mandates that ask you questions of, did the case handler say, I want remedies or not? No, well, that's my interpretation of what they want, but then, no. If they have not said we want remedies, at this point we can't offer it. Okay, then, they did not explicitly say, but just so that you know, culturally, they would never say that in Turkey. Okay, so could you give us a legal opinion that says culturally they would never say this? And, so it gets very complex and it's very interesting as well. On the point of inclusive and sustainable growth, in mega mergers, I think also it has to do with who the merging parties are and what their true DNA and corporate culture is. Because if the country that you're talking about is a country that has issues with corruption, issues with overall compliance matters, freedom of speech matters and all, then a company with a backbone about these kinds of things engaging in mega mergers in your country cannot be entirely a bad thing.
I don't know what country you're talking about.
No, I
It's
wouldn't
okay.
know.
Go.
On the hostile takeover, I mean, for sure, that adds complexity, and I think in particular, and I'll mention one case in Canada where BHP made a hostile bid for the Potash Corporation of Saskatchewan. I happened to represent PCS in that deal. We got the government to turn it down under our foreign investment law, which was essentially a political decision. But once you get into that hostile environment, it does put additional pressure on the antitrust agencies, because you have different parties advocating. My experience is that the agencies have been pretty certainly in our, and I think in the U.S. And Europe, they're pretty clear cut about what rights you have as in a situation like that. So it does add some complexity. I'm not sure it just moves it more into the PR, GR world and the political side of things. On the sustainable growth, to me, the problem we've got there is that we're not moving away too far, I hope, although one sees great nationalist tendencies around the world these days, from globalization of the world economy. And if that continues, which in my view is going to be good for the overall growth of the economy in the world, then it does place an emphasis on us trying to come up with some relative standards and certainty about how these deals will be assessed globally. And so it puts a real pressure, in my view, on the antitrust world in particular to try to move towards more convergence. But my concern is, as I said, I think it's becoming harder and harder to move to convergence.
Can I just talk about this question of growth? I think it's widely accepted now that jobs and a lot of innovation will come from small and medium enterprises if you compare them with these large, often monopolistic firms. So it is true that with rising concentration, you do have a concern about growth, especially the inclusivity of that growth. And this is why in South Africa, we take the issue of these firms, because the firms are a very, very important platform in this globalized world, global value chains. Firms have become very, very important on whether your small and medium enterprises are able to enter markets and sustain themselves there. So we do use sometimes measures to ensure that you have the possibility of entry. This is what was discussed about Walmart, and that entry is sustainable. Somebody must take responsibility to create space for smaller firms, because you know that this is where your inclusivity and jobs are going to come from.
Just 2 or 3 words. I thought the first question was a brilliant question. I wish I could answer it, but and I think probably we, at least on the private practitioner side, don't spend enough time thinking about those kind of issues. I generally believe that economic activity on a national or global level is good. It creates efficiencies. I think the prospect of being taken over generally keeps companies lean and hungry, but you can't ignore the literature that suggests a lot of mergers don't achieve the objectives that they set out to do. I think these are extremely important questions, probably for legislators, less so for us on the coalface, but I thought it was a great question. On the hostile takeover, it's clear that a hostile takeover can change the situation. I mean, there are obviously well-known examples of them. I think in practice these days they don't actually occur as often as people might think, and in part these processes are so long it's very hard to maintain a hostile process over 12 to 18 months. You have to go fairly quickly. Just a small world, and I won't go into too much detail because someone involved in the Comcast, Disney, Fox situation, which is not yet played out completely. I think actually if you look at that, it's interesting that competition hasn't perhaps played as much of a role as people thought it might. Fox's original bid for Sky was stymied or delayed by media plurality issues rather than sort of pure antitrust issues. And in fact, when it came to the Comcast and Disney face-off, if you like, for Sky, was pretty much a wash when it came to the competition issues. I don't think agencies in Brussels or in the UK were standing in the way of that. When it's come to the Disney-Fox deal, the verdict's still out, but reading the tea leaves and without disclosing anything that I shouldn't, it doesn't seem like that's shaping up to be a case that the agencies are going to have significant problems with.
Just a final, in terms of the sustainable growth, I think we actually don't really know exactly also what it means in the sense sustainable, inclusive growth. I mean, there are various dimensions. So you think about merger and sustainable growth. I mean, I would say that, you know, having a vertical FDI through merger in a particular country might improve environmental standards because, you know, many of these value chains, they have been constituted in order to you know, respond to environmental or other types of standards and ensure that they are, the whole actually part of the chain, I mean, is complying with the lead firm. So it might have, in this case, a positive effect. But if you think about employment, and what Tembi mentioned before, it might also lead to displace quite a number of smaller firms or lead to, you know, domestic firms lead basically a number of domestic players to go out of the market and possibly have some employment effect. So there can be very ambiguous effects from that perspective. And I think you can only know that by maybe having some post-implementation review and look not just about the price effect or of the more output effect of the merger, but also what has been the effect of these mergers, let's say, on some factors in terms of sustainable development and inclusive growth of employment, in terms of environmental protection, etc. And then you can somehow have an idea, but it's very difficult, I think, to just, you know, say that there is any. There are many different dimensions here to take into account. Yeah.
Okay, so thanks to the panel. We're going to break for lunch for 45 minutes, and so thanks to everyone.